Well, good afternoon, everyone. My name is Todd Christensen with Capet Credit Union. I serve as the SVP of Advancement and Member Experience. We continue our webinar series that we've chosen to call Lunch Money, a financial well-being webinar series. And so we'd like to welcome everybody here today as we continue with our third of 13 sessions throughout this webinar. We'd like to welcome everybody who has joined us remotely. And we do have some special guests from Tree City Advisors, our partners with Tree City Advisors and Real Money Pros. As we get started here this afternoon, we'd like to remind you that there's a couple of viewing options. We'd encourage you to do a full screen and side by side, and that'll give you an opportunity to better see the presentation from our guest presenters today. We also encourage you to click on the chat function, and you'll be able to include information in the chat function, and that will be questions that you can pose that we can either address today if we have time towards the end, or it can be as follow-ups from Jen. So I would like to welcome Jen Wulf from Wulf Legal. We also have Nick Daniels from Tree City Advisors who has joined us today. They are in their location in downtown or near downtown Boise. I'd like to introduce Jen. Jen Wulf is an attorney with Wulf Legal. She specializes in elements around estate planning. And today we'd like to turn the time over to her to be able to share information as it relates to demystifying estate planning. So welcome Ken and Jen, and we will turn it over to you, Jen.
Thank you so much. I am really excited to be able to share this with you. I have been practicing for about 12 years now, and my practice is solely focused on estate planning, and one of the reasons that I love this practice area so much is the chance to talk with couples and individuals and families and really demystify this process. I was telling Nick recently that I read a survey, and I think it was something like only 40% of US adults have even considered doing their estate plans, and most of us have not. And I think that's because we have a lot of questions about what does this mean? What should I do? What are my options? And so that's what I'm here to talk with you about today. And as was stated, if you have any questions, feel free to drop them in the chat function and we'll try to answer them during today's presentation, or I'm happy to follow up with you offline. But one thing I was chatting with Nick about is, we were kind of joking, when you're getting ready to go camping or going out with your family, and for myself, I'll find myself making sandwiches, and I'll be standing there making sandwiches, getting ready for us to go out for the day. And I always think, where's the adult who's supposed to be doing this? Where's my mom? And then I realized, no, you're a grown person and you have to make these sandwiches yourself. And I think there's a lot of things that can qualify for us when we realize, oh, we're the ones that are adulting now. We have to make these adult decisions. And so tying that into estate planning, Nick has volunteered to spend this time with us today, helping to talk through what I would consider an initial consultation with a client. So when I meet with my clients, I like to offer everyone a totally free, like no strings attached consultation to just talk through estate planning, talk through their options. And so we thought, for purposes of this presentation today, the best way to really share this information with you would be to do a consultation with Nick. So he has volunteered to be the guinea pig here today. And so Nick, tell me a little bit about your family and about what you're hoping to accomplish with estate planning.
Okay, so my wife Emily and I, we've been married for 18 years. We have 3 teenage children, 2 boys, 16 and 15 next week.
Okay.
And then our daughter is 13. And I guess really what's going to be most important to us is just to make sure that if something happened to the both of us or one of us, prior to kids leaving the home, we would want to make sure that they're taken care of. And definitely if something happens to both of us, we don't want them becoming, I don't know what the term is, but belonging to the state, right? We don't want
right,
Governor Little
to
adopt our kids or to tell our kids who's going to continue raising them. We want control of that.
Okay. So I think Nick just brought up some really great points here. And this is, again, like I said, all I do is estate planning, but the number one reason I got into this area is because I want to give families peace of mind. And that peace of mind really often comes in 2 ways. So peace of mind in knowing that you have a plan for your assets, And more importantly, for many of us, peace of mind is knowing that you have a plan in place for your loved ones. And if that be minor children, there's a lot of things for us to talk about and unpack with minor children. Some of us have other dependents. We may be taking care of an elderly parent, or we want to make sure that our spouse would be cared for if something were to happen to us. So looking at our assets and then looking at our loved ones and making sure we have a plan in place for both of those. And so really, when we talk about, let's talk about the asset piece first.
Okay.
So when we talk about our assets, there are 3 ways that your assets can pass to beneficiaries. So the first way would be through the probate process, and that has 2 prongs really. So for those folks that I mentioned who are those U.S. adults who have not gotten around to estate planning yet, they have what is called an intestate state. And each state in the union has created a set of statutes, a set of laws that will step in and put a plan in place if you have not done so yourself. So there's a plan for you. You just may not have created it. And if that's the case, then you are intestate, which means you would still go through the probate process, but it would be with that set of state laws supplementing and for the plan that you did not create. Also, you can go through the probate process if you have created a will. So if you have a will-based estate plan, you'll go through the probate process. And in a will, you set forward what you want to happen to your assets. A will is also the place where you would name a guardian for minor children. And there's a personal representative who takes that will and moves it along through the process. In some states, that's called an executor, but here in Idaho, we call that a personal representative. So if you have either an intestate estate or you have a will-based plan, when you pass away, your personal representative will take that plan, will go to the probate court, will open a probate proceeding, and then there's about a 6 to 12 month time period where that probate proceeding works its way through the court process. And there is a bit of a lag in that timing because there's a period of time that statutorily creditors are allowed to come forward and make any claims they might have against the estate. And then there is a time for the personal representative to put together a list of assets that you may have had, looking at any sort of, like I said, any creditors coming towards your account, and wrapping that all up so that at the end of that 6 to 12 month time period, your assets can be passed to your beneficiaries. So while a will-based plan makes a lot of sense for a lot of people, it's just important to know that there is a bit of a time lag while that will work its way through probate court. So that's the first way that assets pass, is under a will. Sort of the next way that we talk about is trust-based planning. And often when we're talking with families, we're talking about a revocable living trust. And a revocable living trust, this is perhaps a poor analogy, but an analogy I often give is it's almost like we're making a pie. So when you create this revocable living trust, you're creating the base, you're creating the crust for that pie. And then when you fund it with your assets, you're creating the full pie, and you would then be able to use that going forward. And so when you create a trust, you're essentially entering into a contract and you're saying, these are my assets and I'm going to move them from my own personal name and I'm going to retitle them into the name of the trust. And then while I am living, I'm going to serve in 3 roles on behalf of that trust. So I'm the grantor, which means I created the trust. I'm the trustee, which means I'm in charge of the trust. And I'm the beneficiary of that trust. So I'm still benefiting from all of my own assets, just as I would have if they were in my own name, but they're held in the name of the trust. And the important factor there is sometimes people say, well, why does that matter? Why does the government care about what the name of the trust is? And it's really for this purpose. Whether you're going through probate or whether your assets are passing through a trust, the thing the state cares about is making sure there's clear title on all of those assets. So they care that they will be able to look at the real property records, for instance, and look at your address, know who owns your home. And that is what they really want to make sure is clear. They want to know for your bank accounts, who should get those, for any stock accounts you might have, retirement account, where do those go? So that's why when we talk about titling of assets, that's really why the state has any sort of a vested interest at all, is they just want to make sure there's a very clear path of transition on what you own and where it's supposed to go. So when you have a living trust, you are taking some of that administrative burden. You are moving those assets that you own into the trust now during your lifetime. You still can control them in the trust, but they then don't need to make that transition through the probate court when you pass away, because you've already done that administrative piece. So that's sort of the main difference between a will-based plan, which has to go through probate, and a trust-based plan where you're taking that administrative step during your lifetime.
Jen, what would be I'm going to assume that there's a time frame advantage. So you mentioned that with a will-based plan, 6 to 12 months, maybe longer with COVID right now.
Right.
Before all of my assets could get distributed to hopefully the people I want it to go to.
Right.
Does a trust-based plan speed that transfer of assets process?
So you'd think I would have planted that question, but actually Nick just has great questions and he's asking that all on his own. And it's such a good question because yes, it does. When you have a trust-based plan, if you were to pass away and not be able to act as your own trustee anymore, your successor trustee would step in and would immediately be able to effectuate whatever plan you had in place. So there's not that time gap, there's not that lag. And so let's say that you have a plan where you're saying, okay, I want my assets to remain in trust. I want them to be held in this trust because I don't want my children to receive them at the age of 18. So importantly to note, as minors, your kids, if something were to happen to you and your wife, your kids cannot inherit those funds now. If you don't have a plan in place, the court would appoint a conservator, be in charge of all those funds on their behalf, but the day they turn 18, they'd have access to them. And so you can remember back to being 18, like we make the joke that car dealerships love this, but as parents, it's maybe not our goal for our kids to inherit amounts when they turn 18. So if you have set up a plan in your will or set up a plan in your trust where you say, okay, I want these funds to be held in trust and I want them to be used for the health and education and maintenance and support of my kids while they're minors or maybe while they're going through college and that sort of thing. And then I'm going to determine based on what I know about my kids, what plan makes sense. And so sometimes people will say, okay, well, I'd like my children to receive a distribution when they turn 25 and when they turn 30, and then the remainder when they turn 35 or something where you get to set the parameters and you space it out so that you're making the decision that makes the most sense for your family.
Yeah, it sounds like, at least in my case, then a trust would actually help me protect my children from their own immaturity. Right. Yes. And until I feel as a father, like they'd be safe and wise to handle my meager assets.
Well, no, and I think that's one of the things I do really like talking with parents about is let's put a plan in place where you're setting the path where if heaven forbid something were to happen to you and your wife and so you're not there physically for your children, what wise pieces can you put into place now to move them in the direction that you would want them to go? And so some of that prior planning allows you to do that. Okay. And then, I want to focus on this piece about your kids and about what sort of planning we'll have for them. But one other thing I want to say, because I did mention that there are 3 ways to transfer assets, and I've only touched on 2. So through the probate process, through your trust, but the third one is really important, and I think it's overlooked often. That would be your beneficiary designation. So do you have any sort of retirement savings?
I do.
Okay. Do you and your wife have any sort of life insurance?
We do. We have life insurance in place, and on both my retirement accounts, our life insurance, my wife is the primary beneficiary, and then my children would be equally split as secondary beneficiaries.
So again, Nick has just hit on a great point for us to talk about, which is beneficiary designations are really important because he has entered into basically a contract with, say, his life insurance provider. And under that contract, he is telling that provider, if something were to happen to me, this is how I want you to pay out these funds. And that life insurance company does not have any obligation to see if he has any other estate planning documents. So let's say he goes through the process, he gets a trust in place, and under his trust, he has very specific directions of what he wants to happen to his funds. But that's not listed on his beneficiary designations on his life insurance policy. Those designations always trump. So we want to make sure that they align with the rest of your estate planning so that you have a plan that fits everything together. So in your case, for instance, having your spouse as your primary designation, primary beneficiary makes sense. But for your minor kids, the issue that you run into in your current scenario is that minor kids can't inherit under the law. So if something were to happen to you and your wife and that money was going to go to your kids, the court would have to appoint a conservator, that conservator would be in charge of those funds, and those funds would go to your children at the age of 18, sort of like what we just addressed. But if you had trust-based planning, you could have your spouse as your primary beneficiary, and then you could list your trust as your contingent beneficiary.
Okay.
So all funds could flow into the trust and then be allocated by the plan that you have in place.
Okay.
So it's just an example of, we want to make sure we're thinking about all of the pieces of sort of your financial picture together so that we can make sure that they flow in the direction that you intend and that there's not an unintended consequence.
Okay, that makes sense.
Yeah, so assets, those sort of the three broad brush strokes about how those assets can pass. But a very important thing that you mentioned that I want to touch on is, you said the reason this is important for you and your wife is because you love your children, you care about your family, you want to make sure that if something were to happen to them, the best possible plan is in place. So right now, if you and your wife were to pass away and there was not a designated guardian for your children, there would be a hearing as part of that probate process, and the court would have a say in who was going to be named as the guardian of your children. I think I just want to make it very clear, the court always wants what's best for your kids, but you're the one that really knows what's best for your kids. And so if you take the step to name guardians now, you get to be in charge of that scenario and make sure that there's not any sort of fighting. One of the things I've seen is that people will say, well, all my siblings are great. Any of my siblings would do a great job raising my kids. And so they don't designate someone. And then there's some unfortunate occurrence where they're not able to take care of their kids. And so then those children are left without their parents, and potentially with aunts and uncles fighting about what care would be best for them. And so I don't say that as a scare tactic, but I do say that because it's really important to me that you feel equipped and empowered to name guardians for your kids and to figure out what you would want for their care.
This may be a rabbit trail, and so if you don't want to ask it, that's okay. But I'm wondering, if my wife and I fail to name a guardian, what are the implications, like say to our siblings, would then the courts start investigating their lives, so to speak, to try to determine which of our siblings would be best? Like,
right. So
are they kind of up for something that they didn't sign up for if I don't name a beneficiary? Or I think guardian?
Really the issue that can happen is that there can be, as opposed to like court-focused inquiry, actually what often happens is that there's family-focused inquiry, right? So one brother might say, well, I'm better because of all these reasons, and then a sister might say, no, really, I'm better because of these reasons, and then there's a lot of back and forth on that. And so by you taking the reins and saying, this is who I would want to be the guardian of my children, you really get to make that decision, and it's really a loving way to take care of your kids. And often what I'll run into with folks is they'll say, well, I want to make an estate plan, but I just can't because I cannot decide who should raise my kids. I have no good options. And so to that, a couple of things to think about. Number one, it does not have to be a family member. It can be a family member, but if you have a trusted friend, community member, church member who you think would be the best person to nominate as guardian for your kids, you can do so. And then the second thing to think about is if it really is a tough decision, or maybe you and your partner are not aligned on how to make this decision for your kids, work backwards. So I always suggest, in most families, there's someone that you don't want to raise your kids. So think about that person and then work backwards and try to think about who you would want it to be instead. And so in Idaho, the document where we name a guardian for minor children is a will. So even if you have trust-based planning, we would create a will for you that has that piece included. So you would name your guardians there. And sometimes I recommend to folks that you might name like your first choice of guardians and then a successor choice, just in case there was some change and that first choice was unable to fill in that role. Another really important thing I like to emphasize for folks is your estate plan is your plan. It can work with you, it can change, it can grow as you need to. So if you, looking at the snapshot that you know right now about the family situation, choose person A to be your guardian, and then something changes and that's no longer the right choice, you can amend. You can make all the changes you need to. So it's not like you're carving it into stone and there's no chance to change it ever again. This is something that you can grow with and work with over the years. But a starting point is always good. So if we don't have any sort of a plan, you haven't really started. But if you have a plan, we amend it going forward. There's a lot of room for growth in that.
Okay, that's really good to know.
So I wonder if our cameras.
Oh, you know what? That camera likes to, I'm hoping everyone can hear us. The camera likes to auto time off.
Feels hear you, but the camera has gone down. As you're making that adjustment, Nick, question to you, Jen. We're talking a lot about the estate plan and the preparation for individuals with young children or dependents who are under the age of 18. Can you talk to us a little bit about those? And I'll use my wife and I in our scenario that I have my mother-in-law living with us. She's of advanced age, and we're working with her on her estate planning. What are some of the considerations that adult children with aged parents should take into consideration as it relates to estate planning?
Todd, that's such a great question. I appreciate you asking that. And the way I really like to address that, and we might just be, apologies for this technical issue, we might just be switching our video here. Okay, there we go. The way that I always like to address that is, in some ways I would refer to us as sort of the sandwich generation. And so not only do we need to think about our own estate plans, and whether that be an estate plan where you have minor children, an estate plan where you have your own adult children, but also we're a generation that's looking towards our parents and looking towards what sort of a plan they had in place. And so not only looking at, does their either will or trust include all of their assets? Is it up to date? Does it reference actually the financial picture that they really have right now? But another thing that is very, very important as we're having this conversation, Todd, is to consider the ancillary documents that make up part of your estate plan. And for those, I really mean documents that are important to have because they will allow someone else to make decisions for you. If you become incapacitated, you're still living, but you can't make decisions on your own. And so what do I mean by that? Well, I mean making sure that both for yourself and for elderly parents, you have a durable power of attorney in place. A durable power of attorney is a document that many of us are familiar with, but we might not really know what it means. And really, with a power of attorney, you are just assigning someone else the ability to step in and act as your agent and make decisions on your behalf. So under a power of attorney, someone can pay taxes, close or open bank accounts, pay bills, close gym memberships, whatever it might be, they can stand in your stead and make those financial decisions for you. And so having an up-to-date power of attorney is a really important thing to make sure that elderly parents have in place. Additionally, a healthcare power of attorney, super important. So if you cannot make your own healthcare decisions, under a healthcare power of attorney, an agent could step in on your behalf and make those healthcare decisions. We also want to make sure that there's a HIPAA release in place so that the folks that you want to have access to your medical information can speak freely with your physicians. And we also want to make sure that there is a living will, or you've thought about maybe a do not resuscitate order, or any of those things that relate to sort of end of life and what sort of life-sustaining care that you would want. If you make those decisions and are able to determine what would be the best for you, then it really is a blessing to your loved ones because it does not push that decision off onto them. You're able to make that for them.
Do you find, Jen, that when you're sitting down with people like me, these conversations regarding my mortality, are most people uncomfortable with those conversations?
Yes, I would say, the barriers, I think, for folks to have created an estate plan are, we all have to allocate our money. And so sometimes this doesn't take priority. We think we should do it, but we just have not gotten around to it yet. B, we just don't know what we want under certain categories. And so we've let that stymie us from moving forward. But honestly, I think the biggest reason is that no one likes to think about end of life. No one likes to have these conversations about, well, when I leave my loved ones behind, what happens? And so often I think that is a sticking point for folks. I like to couch it with my clients like you are really doing yourself a favor because you're giving yourself peace of mind at this point in your life that these decisions are made, they're settled. You can rest assured that your loved ones are going to be left with a plan of action. And so they're not going to be left floundering when you ultimately do pass away, because we know that's going to happen, hopefully for all of us much later rather than sooner, but we do want to have a plan in place for that time.
Yeah, so to me, it just seems like, I know the way that I think, so I'm not going to put this on any of the viewers out there, but for me, I love drawing a line through my to-do list. And so getting this plan in place would allow me to draw a line saying, yes, that plan's in place. Now I can relax, but I also see it as just a real gift to my loved ones that in a very emotional time when I would just imagine they're dealing with, grief, loss, depression, all of those things, at least they don't also have to deal with all of these decisions being placed in their lap when that's the last thing that they want to put energy into processing.
So true. It's really true. And you've just taken that burden and really made those decisions and helped allow them to walk that time a little easier. And, all of us have complicated lives, right? Some people will come in and tell me, oh, my estate plan is going to be so easy. It's nothing complicated here. And when you dig into it, most of us have complications. And so Todd mentioned, many of us are caring for elderly parents. Some of us have our own younger children. Some of us have business interests that we want to make sure we figure out how to align our business interests. So, for instance, assigning over any sort of interest that you have in an LLC into your trust, assigning various pieces of personal property over into a trust. Those are all things that we can work through together. And another topic to touch on is if you are caring for someone or have a potential beneficiary who has special needs, whether they're a minor or an adult. It's really important to think through how will you leave funds for that person with special needs in a way that is most beneficial to them. So for instance, if you have a potential beneficiary who's receiving any sort of government benefits, you don't want to leave a lump sum to them that could potentially boost up their income and kick them off of their government benefits. So we want to really be thoughtful in our approach to how are we considering all of the loved ones in our lives. And if we, in that scenario, like let's say you hadn't made a plan and they just inherited under the laws of intestacy, it could have a lot of unintended consequences that you may not think about immediately. So we just do want to make sure that we are looking at this in a prepared way that can really provide that plan. And some of the very simple, like if you take nothing else away from this talk, some practical things to think about, because I really like giving people practical tips. I call it an evening of adulting. Set aside an evening of adulting on your calendar. I actually I have one set tomorrow, no kidding, because my husband and I joke sometimes that we're the cobbler's kid with no shoes, because I talk about this all day, but we need to make sure that we are doing these things. So in this evening of adulting, go through and look at your accounts, maybe make an Excel spreadsheet, make a list, and just note, like, these are my various accounts. This is where I store my passwords for my accounts. This is information about my life insurance or my stock accounts or any sort of mutual accounts you might have, retirement accounts you might have. Keep those together in a binder. Make a list. Have that so that if someone were to need to pick up and get a picture of your financial situation, they would be able to do so. Also, you could keep a list of family members, like names and information that you would want there. If you have any specific thoughts about what you would want in a memorial service, this is a great place to kind of store that information as well. And then information just about, day-to-day things. It's interesting how many couples I talk to, and one half of the couple will be very invested in their financial situation, will know what bills they pay, will know sort of their outstanding monthly income. And one side of the couple maybe doesn't have as much of a clear picture of that. And so that's just general financial advice to give. But I always want to make sure that you try to keep that information contained in a place where it would be accessible and you could just pick it up and someone could run with it if they need to.
That makes a lot of sense.
Yeah. And it's, again, one of those things that I talk about doing, and I had to literally put the date on my calendar to make sure that I did it tomorrow, so I don't just talk about it and not do it myself. But I think, I wanted to make sure that we leave a little bit of time for questions. So if anyone has them.
Questions. I like your statement around let me turn on my camera here to make this really seem as though we're talking and we are virtually. I really appreciate the statement around adulting. And much as we say adulting with our children, my wife and I have found that is an importance of adulting with our aged parents and
Yes.
being able to go through. And I think you made the statement of not having to deal with the stress and the concern and the worry, as we've gone through this process for the last couple of months of the statements of upon your demise, or if you become you lose your capacity. Those have become sensitive words, but it's really out of a sense of love and care of let's go through those conversations now rather than in the heat of the moment.
That's so true, Todd. And I think sometimes recognizing that these conversations take time, especially with older parents. Many parents are from a generation that they just are very uncomfortable talking about finances. They obviously are getting older, so maybe their end of life is coming sooner. And so it's a hard topic to broach. But I do want to encourage all of you to just think through the loved ones in your life and think through how could I be having conversations now that will smooth the road for everyone on the way forward. And I think that's wise that you're doing that with your family, Todd.
We've had this scenario around term and whole life. In this situation, there is the conversation about what is the ongoing cost for an individual that's at age 80 for life insurance. And there wasn't an understanding of whether it was whole or term life. And we discovered it was a whole life, and there was a value there that was available for the elements upon a person's death to be able to go through the funeral services. And that was an enormous relief just here recently of, oh, it's taken care of and it's okay, and I don't need to continue to have that monthly expense on a fixed income. And so I think this whole conversation is a great value and benefit, not only for those of us with children who are minor, but also elderly parents. So greatly appreciate the input today and the great information.
Yes, and I also would just say this is why I think it's great to get a team of professionals around you. So, working with a financial advisor, working with someone who handles life insurance, getting your CPA, letting that person talk to your estate planner, getting that team on board for you so that those decisions can work in a way that really works for you. But I think I'm going to turn it back over to Todd because I think he wanted to just close us out here, but I just wanted to thank you for joining today. Again, I'm Jen Wulf with Wulf Legal, and I posted my contact information in the comment section. Please feel free to reach out to me with any questions that you may have, but really great to be able to share this with you today.
Well, thank you, Jen and Nick. Greatly appreciate you joining us. Nick is with Tree City Advisors. We as Capit Credit Union have a strong relationship with them. And as Jen has mentioned, being able to bring that team around you and assist you, we turn to Tree City Advisors. We also turn to those that are part of the Real Money Pros program that is hosted on KBOI 670 from 6 to 7 p.m. throughout the week, Monday through Friday. We'd encourage you to tune into that. We as CapEd are a sponsor of that and enjoy having individuals much as, and I'm looking on screen here as Nick as well as Jen, who have a heart of a teacher to help everybody understand hard principles and how to take those small steps to move forward. There's been a couple of questions in here. We appreciate the comments. Thank you and gratitude for CapEd taking this step. We do want to remind you that this session has been recorded and it will be posted at capedcu.com/lunchmoney. Also want to give you an update or a reminder rather that we have Steve Marsh from Medical Plans of Idaho, another person, a part of that team in all of your financial well-being. He will join us this Thursday, again at 12:15, on a conversation about insurances and helping overcome all the challenges that relates to insurances. And then coming up a week from today, we have VP of Consumer Lending at CapEd, Jenny Sanford, and she is going to be talking about credit scores. Why are they so important? How are they created or how are they evaluated? And what can you do to best manage your credit scores? We also encourage you to take a look at capedcu.com/lunchmoney for all the other sessions that are coming up. We have many that are coming up with you, Nick, as well as with Kent, and we appreciate you helping us demystify, I like that word today, demystifying investing. But to everybody who has joined us, thank you for joining us, and we look forward to seeing you on Thursday. Have a great afternoon. Thanks, everybody.
Good job, Jen.